Good afternoon, everybody. I'm going to call today's meeting of Public Service Subcommittee to order, and Madam Secretary, would you please take our roll?
Representative Alexander. Present. Dixie. Eldridge. Here. Johnson. Here. Kiesling. Powers. Chairman Rutter. You have a quorum.
Thank you. Do we have any personal orders or recognition from our members? Seeing none, we'll take up our regular calendar, and first item up is number 1, and it's House Bill 324. Speaker Marsh. We have a motion and a second, and we have an amendment on your bill. Could you give me your drafting code?
4850.
Yes, sir. We have a motion and a second on the amendment. If there are no objections, we'll go ahead and get that amendment on the bill. Seeing none, all in favor of the amendment, say aye. The amendment goes on the bill. And we'll hear about your bill.
Thank you, Madam Chairman. This bill is brought to us by the administration, and this bill, if we pass it, should help with retention and recruitment efforts in the state. This bill was brought to us by the Governor's Office, working alongside the Department of Human Resources and the Department of Finance Administration. It's got basically 3 parts to it. The first one is amendment provides employees with 12 weeks of paid parental leave for the birth or adoption of a child in accordance with existing FMLA guidelines. It also changes how existing sick and annual time is granted to state employees. Currently, their time is accrued month to month. This would provide employees with their time off up front for the year that the new employees are on the service anniversary date for existing employees. Additionally, this legislation changes the definition for voluntary benefits for state employees to allow for state to pay all proportions of all or the employee's match of certain benefits. This will allow for the state to pay for 50% of the employee match for dental care and 100% for the employee match for long-term disability. This legislation cleans up ambiguity in existing language for non-TCRS retirement plans managed by the state so that these employees can continue to access the health care benefits that they are currently eligible for. With that, I'll try to answer any questions. We have some folks from the Department, Human Resources, and F&A if we need further explanation.
Do we have any questions? See, question's been called. All in favor, please say aye. Aye. Those opposed? The ayes have it, and you move on to full committee. Thank you. Next up is item number 2, House Bill 1151 by Chairman White. We have a motion and a second, and you have an amendment. No, yes, you do. You have an amendment.
4707?
4707.
Working off of?
Do we have a motion and a second on that amendment? Motion and second. If there's no objections, we'll go ahead and if there's no objections, we'll go ahead and get that amendment on the bill. All in favor, say aye. Aye. Opposed? Ayes have it. The amendment's on the bill. You're recognized to explain your bill, Chairman.
Thank you, Chairman of the committee. Where this particular bill comes from, all of y'all know that Senator Farrell is very engaged in families, and this is part of a package of adoption, foster care, and new family legislative packages. Now, what it does, it deals with, as you know, we as state employees, we have what is known as a sick leave bank, where if you enroll in the sick leave bank where you can contribute, I believe I was just told, 4 days at the beginning of your sick leave, and then 1 year thereafter, and you're part of the sick leave bank. And then if you have maybe a catastrophic illness later on where that you have to take more time than what you actually have sick leave, then you can go to the sick leave bank and try to get more time off, 30 days up to 90 days, I believe is the figure. What Chairman Hale would like to do and to help with our families with young children, especially if they are foster care adoptive parents or a new family, such is that we add to this particular legislation current law currently prohibits grants of sick leave from the state sick leave bank for illnesses for any member of a participant's family. This bill will allow sick leave to be used by a member on account of an illness of the member's minor child. So if they, whether it be their own child or adopted child or foster care or someone they've taken in, if they have a illness such as cancer and things like that where they have to take off more, then they can delve into this sick leave bank to have more days off for their minor child moving forward. I think it's up to 30 days, up to 90 days, but it's all approved through the procedures of the sick leave bank. And that's basically what the legislation, adding minor children to the sick leave bank legislation, which is already in existence.
Thank you for that explanation. Do we have any questions? Questions been called. All in favor, please say aye. Aye. Opposed? Ayes have it, and you move on to full committee.
Very
Item number 3, House Bill 1316, has been taken off notice. That brings us to item number 4, which is House Bill 1160. That one's going to be moved to the Hill. Item number 5, HJR 5, also is going to be moved to the Hill. That brings us to item number 6, which is House Bill 726 by Chairman Hulsey. Do I have a motion and a second? No amendments filed. Chairman, you're recognized to explain your bill.
Thank you, Chairman, and thank you, Committee. I appreciate it. I will try not to be long. That is difficult for me, but I will do my best. As you know, in the formation of this country, when you had states before there was any central or federal government, they had their own charters and they did their own business. And they got together and they said, there are some onerous things that we have to deal with. It would be good if we had a federal government that could take care of some things. So they got together and they said, let's form a federal government. But they wanted to make sure in the formation of this federal government that there was no mistake that this federal government could only have a very limited delegated power that they gave it. And they wrote a constitution, and a lot of people think the Constitution was written to establish and bestow rights, but it was not. Because government cannot bestow rights. God bestows rights. Government can either protect them and defend them or take them away. So they established a constitution, I think, for the primary reason to create big chains to chain down the federal government so that they only operated in the venue with the delegated powers that they were given. It turns out to be very interesting because when they also wrote this Constitution, they said we're going to divide it up into 3 branches, a horizontal system of separation of powers. They said we'll have a presidential side or a president that's going to be with the executive branch. And then we'll have a legislative branch that makes law that deals with just the delegated power things that we gave you. Now, by the way, what were those things? Well, there was about 18 of them. That's all. Things like immigration, things like coining money, things like creating an army and a navy, things like interstate commerce and trade, those kinds of things. There were about 18 of them. And the founders, when they created this government, they wanted to make sure that the government understood that they were creating, that you have this small little garden to hoe in. It's got these 18 things. All this big garden belongs to the states. So you hoe in your little garden and stay out of our garden. That was their thinking. And in the amendments that they said, they weren't to delegate liberty or freedom because those things are not delegated by government. They're given by God. But when they set that up, it was like they said, to make sure you understand that when it comes to these fundamental things, you don't mess around in them. For example, the First Amendment to the Constitution says Congress shall make no law, none, zero, no law, When it comes to a man speaking his mind, when it comes to religion and the establishment of it and the free exercise of it, you stay out of that. The Second Amendment, the same thing. You stay out of that. The Ninth Amendment, all the rights that we enumerated came from original rights called common law before the Constitution was ever written. And the Ninth Amendment says the people retain all those as well. And of course, the 10th Amendment says what I said about the gardens. You have a small garden, stay in it. We will never give up the sovereignty of states. That was their thinking. So they created these three branches, and they wanted to make sure that if a federal judge said something, it was not law. If the President of the United States gave an executive order, that should only affect the executive branch of government, by the way. It was not law. They also made a vertical separation of powers. The sovereignty of the states was superior. The federal government was inferior. That was the plan. Well, the topic must have come up. What do you do when a judge tries to make law? What do you do if the president tries to make law? What do you do if Congress passes a law that is not constitutional? Well, they must have discussed it because they talked about it. Let me tell you what they said. In Marbury versus Madison, they said, this was in 1803, by the way, they said, a law repugnant to the Constitution is void. In an ex parte with Siebold in 1879, this is what they said. An unconstitutional law is void and is as no law. An offense created by it is not crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be used as a legal cause of imprisonment. In Norton versus Shelby County, they said in 1886, an unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed. In Miranda versus Arizona in 1966, this is what they said. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. When Thomas Jefferson was talking about the Kentucky Resolution of 1798, this is what he said. Whensoever the federal government assumes undelegated power, its acts are unauthoritative, void, and of no force. He added, where powers are assumed which have not been delegated, a nullification of the act is the remedy. That every state, that's our state, that every state has a natural right and duty in cases not within the authority of the Constitution to nullify of their own authority all assumptions of powers by others within their own state boundaries. That's what they said. Well, that played real good for about the first 100 years, and then slowly the federal government began to run tentacles out of their garden into ours. So I want you to understand, this bill does not force the legislature to nullify anything. This bill simply says, if you're going to, this is how you do it. So this bill says there are 5 ways that you can deal with the nullification issue. By the way, this bill says, what is a nullification? It's a process whereby this state makes an official declaration that a specific federal action has exceeded the prescribed authority under the United States Constitution. that action as being ultra vires will not be recognized as valid within the bounds of this state. That said action as being ultra vires, which by that way, that term means it's beyond one's power of authority, is null and void in this state. Now, this bill describes 5 ways that can happen. The first one is if the federal government or the president or a court makes an edict that affects the executive branch of this state, the governor has a right to nullify that, and that affects the executive branch. If a state judge is dealing with a case and involved in that case is a piece coming out of the federal government that judge believes is blatantly unconstitutional, that judge can nullify that piece. The third way you can do it is if a legislator runs a bill of nullification. But there's a couple of things that hang on this. If you run a bill of nullification, you can take it to a committee process and you can haggle over it and argue over it and wrestle on whether it's constitutional or not constitutional and what we ought to do about it or not do about it, but you can't kill it. It has to go to the House floor for a vote, and it has to go to the Senate floor for a vote. There's a fourth way, and that's based on the very first words of the Tennessee Constitution that says all power is inherent in the people. You do understand that all power is not inherent in the legislature. The people loaned you and me part of that power while we're in session. All power is inherent in the people. So the fourth way you could nullify or get a ball rolling to do that is if 10 or a combination of 10 municipal governments and county governments send a letter of petition to the Speaker of the House asking for a particular action to be nullified. And when the Speaker verifies that these are 10 valid city or county governments, he submits a bill with our process that goes through the same process as I just told you as a legislator would do. Has to abide by the same rules. The fifth way, by the way, there is another way, but it's not in this bill. But in criminal court, criminal judges don't tell juries anymore, but juries have a constitutional right to nullify law. But that's not in this bill. The fifth way is if 2,000 signatures of registered voters are submitted to the Speaker of a House in a petition, and you cannot have less than 25 in any county, and they have to be bundled up by county, but 2,000 signatures of registered voters in the state of Tennessee send a petition of nullification to the Speaker of the House, then he verifies those signatures, and then he submits a bill, and it goes through the same process as before. Now, again, this bill doesn't force the legislature to nullify anything. It just says if you're going to do it, this is the way you do it. Now, I know the governor has flagged this bill, and you've gotten visits from really good people, really nice people. They're good folks. And they're worried because they do a good job and they do good work, and they're worried that we'll lose federal money if we didn't talk about this. I got to remind you, you and I stood up on that House floor over there a few weeks ago, and we raised up our hand and we swore to 7 million people in this state. We swore not that we would rake in all the federal money we could get. We swore that we would always defend the unalienable rights of Tennessee people by defending and upholding the Constitution of the United States and the Constitution of the state of Tennessee. We should not be for sale. I want to tell you that deep in my soul, I have a conviction that is deep-seated. I believe that if state legislatures in this country do not stand up and hold the federal government to obey the Constitution of the United States, we could very easily lose this republic. That's what this bill does. There you have it.
Thank you on many levels for that history lesson. Thank you very much. We do have some people here today that would like to give testimony. Without objection, we're going to go out of session to hear from them. First up, we're going to invite Bernadette Pager. Ms. Pager, please identify yourself and tell us who you're with, and understand that you have 3 minutes.
Okay, thank you very much. So my name is Bernadette Pager, and I'm here today representing myself. I enthusiastically support HB 0726, and I believe it is necessary for the preservation of our state, our nation, and our very freedom. I'm so touched by what Rep. Halsey just said. Until fairly recently, I didn't really understand the importance of the structure of this nation. I'm almost 60 years old, and I didn't understand the beautiful structure of this nation until recently. I didn't understand that the separation of powers between branches and of government and between the layers of government are what keep us all safe and strong and free and also united, sort of like good fences make good neighbors. There's strength in separation and protection in checks and balances. This bill strengthens both. While our nation is built upon separation of powers and checks and balances, unfortunately, much of our infrastructure is not. At the federal level, there are agencies that hold great sway over many issues, and these agencies are tangled in layers of public-private partnerships that deeply influence their direction. These agencies issue guidelines, rules, even mandates that are pushed out to all the states, who then push them out to county and city agencies, as well as the private business sector, and eventually it all gets pushed onto we the people. During the past couple of years, these administrative orders have led to harm at every level of society. Families were torn apart, marriages split, lifelong friendships ended, businesses bankrupted, education interrupted, lives interrupted, suicides among our young people reached historical levels. Why? For the most part, there are no checks and balances built into this administrative infrastructure. Questioning or challenging of the information is not encouraged, and no real pushback is tolerated. In fact, if you're part of that extensive administrative network, criticism is discouraged, and pushback can get you a pink slip. I've heard this described as the administrative state. It's not a republic. At times of public health emergency like we just experienced, with so much unknown with science and medicine emerging and consequences of policies ignored, this unchecked federal administrative power has proven to be dangerous and divisive to this nation. Add to this the corporate capture of major media who side with the administrative state and the censorship happening on media platforms, and we end up where we are today with our very foundation under threat. I don't know if you're aware that this very bill is being discussed. It has gone viral among citizen groups. People around the nation love this bill. You might not hear about it on major media, but we, the people, love this bill. I've heard from friends in other states saying how much they love it. They are praying that it passes.
I'm sorry, Ms. Pager. Would you just please wrap it
Yeah.
up? Your
What-
3 minutes are up.
Thank you. Okay. And other states intend to bring their own legislators this as model legislation. So your vote today on this bill is truly historical. I appreciate your hearing me today. I'm nobody really, and yet I'm everybody. I'm not paid to be here. I'm here because I love this nation, and I love my new home state of Tennessee, and I believe this bill is needed to save both. Thank you.
And thank you for your testimony. Do we have any questions? I'm sorry. Do we have? Okay. Now I'm going to ask Valerie Yancey to come up and talk with us.
I still love you, girl.
Please identify yourself and who you're with.
Madam Chair, Valerie Yancey with the Governor's Office. I think I will live to fight another day. Thank you.
I think that is all of the people that we have to testify today. Am I right? So we're going to go back into to session. And Mr. Chairman, Mr. Bud Halsey,
Yes,
you
ma'am.
have the floor.
Thank you. I just have one other comment. Nullification is nothing
I'm
that
sorry.
is foreign even in these times. In the last 10 to 12 years, there is about 20 to 30 federal laws already been enacted and passed in Congress that deal with marijuana. Growing it, there's laws against growing it, there's laws against smoking it, there's laws against possessing it, there's laws against selling it, there's laws against taking it across state lines. In the last 10 to 12 years, 22 states have said to the federal government, this is not your bailiwick. This is our garden. And we're going to sell it, and we're going to grow it, and we're going to smoke it. 22 states nullified 20 to 30 different federal laws. This is not foreign.
Do we have any questions? Yes, Chairman Powers.
Do you have questions for this lady?
First of all, thank you. You know, one thing I keep hearing on the House floor, Representative Halsey, is that we live in a democracy. Do we live in a democracy or a republic?
This is a republic.
That's
what it was
right. And I
designed
think
to
if
be,
I hear
yes.
democracy one more time on the House floor. But I was just wanting to know, one thing that you mentioned, and one thing that I see happen all the time, the federal government takes money from us through our income tax. It goes to Washington. Then they hold it back and say, if you don't do this, we're not going to give you this federal money. And it's our money that they are holding against us and putting strings on it to make us do what they want to do. And I hope something like this will help to nullify that particular thing that they're doing. I guess the only, and the other thing that I worry about too, we have state constitutional amendments. I'll just throw one out there. We have marriages between a man and a woman. They overruled that, and it's in our state constitution. Just other things like that too that they're actually in our state constitution. So they're taking away our rights with a judicial branch of the government, judicial activists, and I hope something like this would help nullify that part of it too. So I guess the only thing I have that about your bill that worries me just a little bit, I wish you would change it just a little bit, are the 2,000 signatures. I wish we would have, I think it should be more. I think it should be, I don't know, I mean, maybe a percentage of the population, maybe 1% or 0.5% or something like that. But 2,000 signatures and more is not a lot. You could get one subdivision, you know, and end up getting 2,000 signatures for a particular thing. That's the only issue that I had with it. Is there any way that you might consider amending that?
I'll tell you what, if you pass this on to full committee, I'd be more than happy to sit down and come up with a number that you're happy with.
Okay, that was the only question I had. I mean, I've been very familiar with this process for a long time, and you did a great job explaining it and made a great case for it. So thank you.
Chairman Halsey, do you have any closing remarks?
No, ma'am, none at all. Thank you for
We have a question on the bill. All in favor of Chairman Halsey's bill, please indicate by saying aye. Aye. Those opposed, no. The ayes have it, and you move on to full committee.
Thank you, Chairman. Thank you, committee.
Next up is House Bill 1070 by Chairlady Carringer. Do we have a motion and second? Chairlady, I believe you have a drafting code.
I
Have
do.
an amendment,
Yes.
drafting code
004625.
04625, okay. Do we have a motion and a second on the amendment? We do, and let's go ahead and vote on that amendment and get it on this bill. All in favor, say aye. Those opposed? The ayes have it. The amendment's on the bill, and you're free to explain your bill to this committee.
Thank you, Chairman. So House Bill 1070, it's legislation to prohibit local governments from purchasing drones from manufacturers with ties to the Chinese government or other agencies that may inappropriately monitor U.S. citizens using spyware. The amendment, which doesn't make the bill, but the amendment is to put on there to allow first responders that use the technology tools that have already purchased until they're budgeted for regular replacement. It's a compromise with the local agencies to make sure we're balancing public safety with realistic budget constraints of local government. So I do have someone that can speak here, and if y'all would like to, that is good, whatever the committee desires.
What's the will of the committee? Do we have any questions for the sponsor? I think question's been called. All in favor, please say aye. Those opposed, no. The ayes have it, and you move on to full committee.
Thank you very much, Chairman and Committee.
Next up is House Bill 706 by Chairman Doggett. We'll roll this bill to the Hill. Next up is item number 9, which is House Bill 622 by Representative Garrett. Do you have a motion and a second? No amendments filed. Representative, you're recognized to explain your bill.
Thank you, Madam Chair. This is legislation from a constituent of mine. Her name is Debbie Mathis Watts, and she has written a song called The Tennessee in Me, which we want to designate as one of the songs for the state of Tennessee. And let me tell you a little bit about her. I have been requested to sing these lyrics, but I'm hoping to get a positive vote out of this committee. I'm afraid that would kill it faster than I can even say The Tennessee in Me. But Miss Watts is a lifelong Tennessean. She, in fact, is as a 4 or 5 generation Tennessean. Her great-great-grandfather was actually a member of this body in the 59th General Assembly. Her first memory is playing the piano as a child, and that's where her musical career started. She actually has a very large, long bio that I'm going to try to tell you all about her just in a few words. She is a current staff writer, performer, television writer, producer at the famed Nashville Network, and she is now a co-CEO of the Tennessee Stage and Film Company. She often plays at the Hermitage Hotel. She often plays at the Ryman. She writes, she composes songs, and they all, believe it or not, relate somehow to the state of Tennessee. So when she told me her story, I thought it was more appropriate that one of her songs can become one of the songs that Tennessee records as a Tennessee song. So that is The Tennessee in Me, and if I am so lucky to move this on to full, I hope to have her here, at least where she can see and be introduced, and then potentially perform the song on the floor if it so allows. So with that, Madam Chairman, I'll be glad to take any questions, but I cannot do as well as Representative Halsey just did a couple of bills ago.
Do we have any questions for our sponsor? We have a question called on the bill. All in favor, please say aye. Those opposed? The ayes have it, and you move on to full committee.
Madam Chair and Committee, thank you very much.
Thank you. We're going to go back to item number 8, and that's House Bill 706 by Chairman Doggett. Motion. We have a motion and a second, and you do have an amendment. Could you give me your drafting code?
It's 4453.
4453.
Provided with some inaccurate
Do we have a motion
information.
and a second on the amendment? Do we have a second? Is there, no objections? Okay, we're going to go ahead and put that amendment on the bill. All in favor, please say aye. Those opposed? The ayes have it. The amendment's on the bill. We're ready to listen to you explain your bill to this committee.
Well, thank you, Madam Chair. And I know last time I was here, we had a very educational presentation.
Yes, we did.
Unfortunately, today I won't be able to provide the same entertainment as we did last time, but I appreciate this committee very much. What we are doing here, this is a very important bill. This is a return to work bill that we're doing for law enforcement officers. As you've known, over the last few years, we've had issues with retention and recruitment of law enforcement officers across this great state. This is going to put them in line with other return to work initiatives that have come before us already. A law enforcement officer, after they retire, will be able to, after 60 days, they'll be able to come back to work in a department. They will be able to draw an unlimited salary. That'll be something negotiated between them and those departments, and then be able to draw 70% of their TCRS.
That's it. That explains your bill.
Unless you know something I don't know.
I'm just making sure.
Yes, ma'am.
Do we have any questions? Questions been called. All in favor, please say aye. Those opposed? Ayes have it. Your bill moves on to full committee.
Thank you so much.
You're welcome. Next up is item 10, House Bill 1036 by Representative Shaw. We have a motion and a second, and you do have an amendment on your bill. Could you give me the drafting code?
Yes, ma'am, I can. It's 004238.
Do I have a motion and a second on this amendment? We'll go ahead and get this amendment on the bill. All in favor, please say aye. Opposed? The amendment goes on the bill, and now you're recognized to explain your bill.
Thank you, Madam Chair and members. This bill comes to me through Senator Wally. There was a little bit of a problem in our district where I represent and he represents, and of course, the treasurer had to fix that problem, and so the treasurer brought this bill to Senator Wally, and of course, he asked me to carry it on the House side. And what it deals with, it authorizes all public employers to require a new employee to sign a certification acknowledging that the employees, that they understand what the employees are and what the duties of their obligation is concerning their retirement system. And that's really what the full amendment does, which goes in more details. And I'm certainly willing to explain that if I need to, because the amendment actually makes the bill. And thank you so much. And I have this information here before me the committee would like to hear. All right, thank you so much. Current law generally prohibits a public official or an employee from having multiple memberships in more than one retirement system that is funded with public funds. They cannot accrue a pension, that is, or retirement benefit in more than one public employee retirement system based on the same period of service. And of course, current law provides the following exceptions to this general prohibition. And of course, federal law requirement, it's a federal law requirement program, a local retirement system or tax deferred retirement plan, meaning to define a benefit or a deferred compensation plan where the combined employee or employees' contributions do not exceed more than 3% of the employee's salary. And the amendment adds a new exception indicating that it defines benefit plans that are established and maintained by a local government employee that is supplementary to the employee's participation in the TCR program, which exempts or provides the local government plan. Of course, it was established prior to the effective date of this act, and the total combined employer and employees contributions do not exceed 7%, and the supplementary benefits are subject to the Internal Revenue Service limitations on the maximum retirement allowed payable to that member. And of course, as I said, this was a small problem that was in one of our districts that the treasurer had to fix, and then he asked us to carry some legislation to put this in, to codify this so this would not come up again. I would entertain any questions, please, ma'am.
Thank you, sir. Do we have any questions for the sponsor? Questions have been called. All in favor, please say aye. Those opposed? The ayes have it, and your bill moves out to full committee.
Thank you, ma'am. And if I could make a request, I'd like to take House Bill 1517 off notice.
You sure may. Without objection, House Bill 1517 is off notice.
Thank you so much, Madam Chair and Committee.
Thank you. I'm going to go, we're going to the hill, right? We're going to go to the hill of the calendar and pick up item number 4. House Bill 1160 by Chairman Todd. I understand that this bill has been rolled?
Yes, 1 week.
Okay, we're going to roll 1 week.
Thank you.
Next up is item number 5, which is HJR 5, also by Chairman Todd. And you're recognized. Motion and a second. Do I have a second? Second. You're recognized on the bill, Chairman Todd.
Thank you so much. This is a resolution for an Article 5, calling on the Congress to call an Article 5 convention of the states for the purpose of imposing term limits on the U.S. Congress. This resolution makes an application to Congress as provided by Article 5 of the Constitution of the United States to call a convention limited to proposing an amendment to the Constitution of the United States to set a limit on the number of terms to which a person may be elected as a member of the United States House of Representatives, and set a limit on the number of terms to which a person may be elected as a member of the United States Senate. We've done this before, and this is just a renewal of a resolution that we've done in the past, and I can go into a lot of details on this about polling and other things. I think most of you know how well this is one of those topics that when the public is asked what their opinion is, they are very much in favor of term limits on Congress. I firmly believe that if we get close to the 34 states it takes to do this, that Congress will probably hit the skids really quick and come up with their own terms and their own limits so that we don't have to do that. So that would leave them in charge, but this will be a catalyst to do that. So I'll be glad to take any questions.
We do have testimony, but go ahead with your question. You want to wait? Okay. We do have testimony. Is there a Mr. Stephen Puckett in the audience? Mr. Puckett? Would you please come up and identify yourself? Oh, yeah, we have to go out of session. Excuse me. Just a little blip there. Mr. Puckett, please identify yourself and tell us who you're with.
All right. Thank you, Madam Chairman. My name is Stephen Puckett.
Excuse me, sir, but you do have 3 minutes.
Yeah. Thank you. Thank you, Madam Chairman. My name is Stephen Puckett. I reside in Hendersonville, Tennessee. I'm a resident of Hendersonville, Tennessee, and I am here in opposition to this. And I respect and appreciate. I actually do appreciate the spirit of the sponsors' initiative with this resolution. As someone who actually supports term limits for the executive branch, however, with the legislative branch, it becomes a bit problematic with the issue of timing of elections, and where nefarious powers can time up elections, but it especially becomes a problem at the national level, where nefarious actors such as foreign enemies of our nation and as well as foreign powers, which was what our founding fathers actually called corporations and global citizens, they could time up our government to be able to try to take control, or more importantly, create a disadvantage where our Congress, our entire government's not familiar with the levers of power, or even more dangerously, install a Manchurian candidate in the executive branch to attack each branch, our first branch, which would create a crisis within our nation. Now, the most dangerous of it, though, is the one that we see pop up time and time again with term limits at the local level, and that is a government that is not answering to the people. The Founding Fathers discussed this at great length, and they emphasized the reason why our House of Representatives is up every 2 years is because Congress must always be under the yoke of accountability to the people. They have to face the people at the risk of losing their job. And that's the key here, because if a Congress is term limited, where every member of Congress, Senate and House, are on their last term limit, they have no accountability to the people. They no longer have to face the people or its consequences outside of the Second Amendment, and in which that is the greatest disaster we could ever have. Thank you.
Thank you. Do we have any questions? Seeing none. Oh, you do. We do have a question for you, Mr. Puckett.
Sorry about
Chairman
that.
Thank you,
Powers.
Madam Chair. Yeah, going back to what you said, and I completely understand, and it makes a lot of sense. One thing, if the term limited about answering to the people and whatever, but we're already term limiting our president, so do you think that applies to him too? That lame duck, 4 years, that he's not really having to answer to the people.
I was going to say, that's also another demonstration is that, the second term of the president usually goes wild. The thing is, that's why we have three branches of government. We have, the Supreme Court that is lifetime appointed, thus theoretically not accountable to the president or to the other two branches. Mm-hmm. They check each other. But Congress has to answer to the people at all times. And that's the key, is that at least one branch is always accountable to the people. That's the key.
Okay. All right. Thank you. Thank you, Madam Chair.
Any more questions? Seeing none, thank you for your testimony. We're going to go back into session. Do we have any, do you have any remarks?
I guess I would just say that we have a number of things built in, number of checks and balances built into our system, and even if a portion of Congress, both the House and Senate, have a term limit that's coming up soon, that we still have the majority of members that are not term limited at that time. They're still going to be serving with the anticipation of being reelected. So then you also have the executive branch veto power of anything that might come out of Congress that would not be positive. So I think we've got that built in, and I think our founders intended, as I think most of you know, for our legislature to be a citizen legislature, not a career. And as it has developed over many decades, we've seen it become a career for a good number of the folks serving in Washington. And the people don't really have the ability to change them out, it seems like, anymore, because the financial burden is such for an individual to want to run for Congress, either the U.S. House or the U.S. Senate, that it's almost insurmountable. And so until someone decides they're not going to run again, then it just usually doesn't leave an opportunity for new blood. And we've seen a lot of that just in this state over the last several years. I've had experiences with different folks running for Congress that just could not gather the financial support to get the word out. And so when you have an incumbent that's getting everything. So I think most of you see that, you know that, and I think we have the checks and balances necessary in our system so that those lame duck individuals will not be a concern.
Do we have any questions for our sponsor? Yes, Chairman Powers.
Okay. Thank you, Madam Chair. Yeah, was there any proposal, I know kind of dealt with this before, was there any proposal about the number of terms for either the House or the Senate, either one. Has that come up or arisen?
You're recognized.
It's not something that's part of this resolution. It's not something that I have really worked on. I think we're going to leave that up to our delegates. Once we get this convention called, then we will instruct our delegates. I would imagine our General Assembly would probably put together some ideas for that and send our delegates with those ideas to vet out in that particular convention.
Thank you. Thank you, Madam Chair.
Chairman Kiesling.
Thank you, Madam Chair. Well received your comments, Chairman. It's been a long day for me and most of us here. Let's go back to the previous year. We did, help me, catch me up, and I've forgotten. We did this, you did this last year, did you? Was it last year?
I don't remember the exact time. It may have been a couple of years ago now. I'm trying to remember.
So it's not like we have to pass this resolution 3 times, and I mean, it's not anything like that then. So what can we accomplish then out of if we pass this and pass it on through the House floor then, or get it off here? Where's this lead us? Where's this going to take us then now?
You're recognized.
Thank you.
As a reminder to me here, please.
Sure. I think it's encouraging to other states that maybe have been toying with the idea that just haven't done it yet to say, that things are still solid in most states to call for this convention and to go this route. And as I said earlier, I think it sends a message to Congress that we intend to do this, and we would prefer they take the lead and put their own limits on. And I think they would answer to the people for that. And I think it would be a very positive thing. But I think this is encouragement in both directions, whether for Congress to do it or just other states to join the cause.
I concur. Thank you very much. Thank you, Madam Chair.
Chairman Powers.
Thank you, Madam Chair. I think one thing he might have been mentioning there that it takes 34 states to make an application to Congress, and it takes 38 states to ratify the amendment. So I think that might have been one number. You didn't mention that, but I know you know that and everything. But I know that has to. We would only be with the one state, and then we need 33 more. Are there any other states that have already passed it? Do you know that at this point? Yeah.
There are. I don't have that number with me fresh, but that's something obviously with other
Sure.
legislatures meeting that. Information I need to get current on that, and I'll try to have it before full committee if y'all so desire.
All right. Thank you. Thank you, Madam Chair.
Do we have any more questions? Are we ready to vote? Question's been called. All in favor of this resolution, please say aye. Aye. Opposed? No. I'm a no. The ayes have it. I'm sorry. I was moving on. You're headed to full committee. Thank you, Chairman Todd. We are now on item number 12, and that is House Bill 1135, and that has been rolled for 2 weeks. On to item number 13, that's House Bill 1100 by Representative Hakeem. We need a motion and a second. We have a motion, we have a second. Just a moment. I would like to remind everybody that House Bill 1100 was previously considered, amended, and reset for today's calendar, and so today we're considering the bill as amended. So we do have a motion and a second. And Representative, you're recognized to explain your bill.
Thank you very much, Madam Chairman and members. Some of the reasons for bringing forth this bill is that over 100 people move into the Nashville community in the state of Tennessee every day, and people from all demographics. And as a result of that, we looked at the 2020 census, and what that told us is over 100,000 people identify themselves as multiracial. And what we believe this bill would do is to assist law enforcement in training them on states' various cultures and prevent negative events from occurring. We want police to go home safely. We want the community to feel safe. And something I neglected to do at the beginning was to reiterate the fact that I have 5 family members who are either presently in law enforcement or have been in law enforcement. And I would also mention that the University of Tennessee provides training in areas that is also described as de-escalation, critical decision-making, ethics, bias mitigation, and Governor Lee proposed enhancing a number of techniques, again, de-escalation techniques, duty to intervene, officer wellness, public assembly, and community interaction. Those are some of the items. Now, presently, POST, what they provide is a 30-hour basic training for new employees coming aboard. What this legislation would be something that's done yearly, sort of reiterating the importance of what is being taught, as was described by the University of Tennessee and our Governor, Bill Lee. And what we would ask is that we instruct, or through this legislation, POST to develop and implement this type of training. Some would say that they already do this, a form of it. But the reality is, from what I've read, what they do now, which is in-house, is something that has been done since the POST was created in 1981. And we know there's a lot of changes in the community, there's a lot of changes in policing that things need to be updated. So we're proposing to put this training in place, not only, again, I say, to help police, but to help the community as a whole. I would mention, Madam Chair, that we have someone in the audience, I don't know if they want to speak, and from POST and from Physical Review. I guess they're available if you're so inclined to do so. And I defer to you.
Members, would you like to hear from, so yes, we would. So did you say from the POST and from Physical Review?
Yes, ma'am.
Okay. We'll do Chip Kane with the Post Commission first. We're going to go out of session. And I think we have Deputy Commissioner Jennifer Peck with us. Would you please identify yourselves and give us your what department you're with?
I think I turned it on. I'm Jennifer Peck. I'm the Deputy Commissioner of the Department of Commerce and Insurance.
Chip Kane, the Executive Secretary of the Post Commission and Director of the Tennessee Law Enforcement Training Academy.
Commissioner Peck, would you go first?
Sure. We just wanted to be here so that we could clarify the distinct roles between Toledo and Post. They can occasionally be confused, and so we wanted to clarify the roles. Toledo is the Tennessee Law Enforcement Training Academy, and Toledo develops and then administers training, so basic police school. The Post Commission is the Peace Officer Standard and Training Commission. That is the regulatory body, the regulatory authority. So because of those two can sometimes be confused as to their distinct roles. We met with Representative Hakeem, Commissioner Lawrence, Director Kane, and I spent a little over an hour with Representative Hakeem to try to clarify that and to express what we would need to see in the changes in order to implement the legislation.
Thank you. Go ahead.
Excuse me, I'm just available for questions. I think.
Oh, okay. Do we have any questions for our guest? Do we have any questions? Chairman Powers?
Yeah, thank you, Madam Chair. Commissioner Peck, would you just talk a little bit about what would be, you were talking about what might, changes might be needed made or in the legislation to administer this particular, could you talk a little bit about that, please?
Sure. The legislation requires that Post develop the training, and since Post does not develop the training, we would ask that that be changed. Post will, instead of developing the training and sending it out all across the state, what Post does is the local agencies make their own training that's specific to their communities, and then Post approves those or does not approve those. So that is one of the changes, is that Post wouldn't actually develop the training, and there's some smaller issues with the certificates being issued, but that's the largest issue. And I noticed that there's no physical impact, no note on this. Would it not require more training? Would that not require more training to go through this? I mean, wouldn't there be a physical impact? Okay, Crystal, come up. Okay, all right, thank you. I'm good, thank you.
Chairman Johnson, you're recognized.
Thank you, Madam Chair. What diversity training do we offer at the present time?
So, for Toledo, the basic police school, we offer about 30 hours, and Director Kane can get more into the specifics of that, but there's about 30 hours of diversity training. On the in-service side, because you've got the basic police school to become a law enforcement officer, and then you have the in-service trainings in order to receive your pay supplement, which is 40 hours. This year, they are doing, there's 2 hours of community involvement, and I want to make sure I don't misspeak because it has changed. So there's 2 hours of community involvement. There's 1 hour of de-escalation and duty to intervene, and then 1 hour of public assembly interaction, and then 1 hour of officer wellness. That's this year. And then Director Kane might be able to speak more about the in-service requirements for diversity.
Sure, and at the Tennessee Law Enforcement Training Academy, we have 5.5 hours of training at the end of the first day of the first week of the academy that's dedicated to just and fair policing. And so there is no specific requirement for this on an annual ongoing basis. However, going back, even before now, before 2018, this training, some form of it was required as a part of basic training through the 30 hours of, I think it's interpersonal communications. But in 2018, every law enforcement officer currently serving in the state was required to go through this training. So based on the fact that it had been a requirement prior to 2018, and everybody that has gone through the academy has received it, and every officer in the state has received it, this training has already been conducted.
After the fact, would you go ahead and identify yourself?
I'm so sorry. Chip Kane, Tennessee Law Enforcement Training Academy.
I'm sorry, I didn't remind you. That's okay. Do we have any questions for our guest?
Thank you, Madam Chair.
Go ahead. Chairman Kiesling.
Thank you, Madam Chair. The sponsor, to you, Mr. Kane, sponsor, of course, again, and I don't want to sound redundant, but Commissioner Peck, you mentioned the 30 hours of training. So in the sponsor's remarks, I understood him to say that this legislation would require annual training, but I didn't hear him say how many hours of annual training. Could you tell me? Could you tell us how many that?
You're recognized.
Yes, so that is one of the things that we would need in this bill, is to have more specificity as to the requirements, whether they be annual, how many hours, the specific subject matter that would be needed.
You're recognized.
Could it? Thank you, Chair Lady. I've been told that you, the department, and the sponsor met, and there'd been suggested some language, some changes to the language. Maybe not. You all were anticipating an amendment, but there hasn't been one, has there?
You're recognized,
Commissioner.
We are not aware of an amendment that addresses those concerns.
Okay. Thank you, Chair Lady.
Do we have any more questions for our guest? Seeing none, you're excused, and I do believe we have one other, Krista Lee Karshner with the Director of Fiscal Review. Do you want to go ahead with your testimony, or do we want to just take questions? Or you're just here to take questions? Okay. And I think we have a question from Chairman Powers.
Yes, thank you, Madam Chair. I was going to mention, I didn't see any physical note, but I would think that there would be, if we're doing additional training, would that not encourage some type of additional revenue?
And let me interrupt. We need your name and your department for the record.
Krista Lee Karshner, Executive Director of the Fiscal Review Committee. Representative Powers, from our viewpoint and the way the language of the bill as amended reads, the current rules of the Post Commission of the diversity, sociology of group, ethnic, and racial training would cover the broadness of the bill, of what's required. And so there is that training that's already developed and available out there. There is a UT training that they do that does cost, but it would be a permissive cost if the local governments wanted to do that. There are several that go through that training, but it's up to them. But there is something technically available right now.
Okay.
Yeah.
You're recognized.
So it sounds like, I mean, it's based on what I've heard and the testimony that we're already doing this. The only change would be maybe an annual rather than, so we're not really adding anything additional.
I think the difference would be that this would be something in statute, and right now it's just under a rule.
Oh, okay. Gotcha. All right. Thank you, Madam Chair.
Any more questions? Oh, Speaker Johnson? She answered. Any more questions? Thank you. We're going to go back into session. Representative Hakeem.
Thank you very much, Madam Chair. If it's appropriate, I would like to get, I guess, clarification or some understanding from attorney, if I could.
Sure. We'll go out of session and speak with our attorney.
Mr. Attorney, in regards to the post-commission powers and duties, I think we're looking at 38-8-104 as far as the type of training we're talking about. Is it your interpretation, understanding that posts would do this, or I don't want to put words in your mouth. You tell me, as you understand it, who's supposed to be doing this?
Thank you, Matt Mundy for the record from legal. Just generally speaking, I think part of the confusion from last week, if I may take a little latitude here, that's caused some confusion, I think, between the committee members and the sponsor and even the post-commission are the differences between the commission's statutory obligations and what they do in practice, where they review policies that are developed and implemented by law enforcement agencies, and I could be wrong, but this is my understanding, and then the post-commission reviews those policies and that training. The statute, however, under 38-8-104 says the commission shall develop, plan, and implement law enforcement training programs for all law enforcement officers in Tennessee. Now, it's my understanding that the post-commission is not doing that right now, that they're not developing and implementing the policies for all the law enforcement agencies across the state. The bill in front of us tracks that same language, which requires the commission to develop and implement law enforcement training with respect to these particular areas. And so it's not inconsistent with what the Post Commission is purportedly supposed to be doing under statute right now. Does that answer your question?
Does that
Is that a fair?
Yes, sir. Thank you very much.
Any more questions for legal? We'll go back into session. Do you have any closing remarks?
Yes, ma'am. First of all, thank the committee for the opportunity to make these observations. And I think what we've heard is that the Post or committee is supposed to be doing these things. It all depends on who we talk to as to whether they're doing it, if it should be done, or they don't do it. I have emails that say those things. One email, this is all from insurance, what is it, Commerce and Insurance. We don't do it, it doesn't exist, we do it. So I feel I'm fairly clear on the fact that Post is supposed to be doing this. And the last word I heard from the Commissioner of Commerce and Insurance is that they were going to have to go talk either with the governor or with the governor's staff as to, I guess, what they do from here. And, you know, I feel my understanding, we set the law, we set the guidelines, and I'm appealing to this commission, to this board, to allow me to move forward in the next step. And if there's any understanding that I need to have from you going forward, more than willing to do that moving forward. Thank you.
Chairman Kiesling.
Thank you, Chair Lady. Sponsor, I've listened. I've tried to understand here. I think there's just somewhat of a redundancy here. I can't. I will be voting against this. I just think we're duplicating, or would be, and taking time from those that. Well, anyway, I'll end it at that. I will be voting against this. But thank you, Madam Chair. Thank you, sponsor.
Thank you. Are we ready? Oh, you have a question. Go ahead, Chairman.
Thank you,
Powers.
Madam Chair. Yeah, and thank you, sponsor. And you know, I have great respect. We got to serve on committees together. Yes, sir. My dad was in law enforcement too, as a police officer. He died 2 months before his retirement. So I'm very familiar with, you know, with so many different issues that they had to deal with. You know, and back then, which was many years ago, it was, you know, you go treat everybody equally, race, creed, color, rich or poor, you treat them equally, or you're off the force. I mean, that was pretty much it. And I think, you know, when we talk about the training that's already being offered, I don't think it's something, you know, I think if it's a one-time thing, I think, and I go back to what Chairman Kiesling said, I think it is a little bit redundant that we're already doing something like this, and I don't think it's something that has to be honest with you, has to be done every year. If you've got that in your heart, if you're treating people the way they should be and treating everybody equally, and hopefully they all are, and we all should be, then, you know, maybe this the one-time training, you know, I think would be enough. It would be for me when I got trained for my job. I only went through training 2 weeks before I started working 34 years ago, and nobody had to tell me, you know, every year or what to go back and do and everything. But I appreciate you bringing the bill anyway, but I'm not going to be able to support it either. Sorry.
Yes. Excuse me. Do you want to
Yes, ma'am.
address that?
Yes, ma'am. As we look at policing as to what it was when this bill was first put into place in 1981 and where we are today, in the safety for officers and the community, changes have occurred. And if we look at what the University of Tennessee offers, you know, it's been brought up to date. I question if the training that is given now is beyond what we had in 1981. It's still under the same titles as 1981. And so I guess I look at events like the horrific death in Memphis, 5 officers beating a person to death. We look at Nashville and other cities around the state. There have been instances where we have to question if these officers have had enough or proper training. You know, I look at the fact that we have ethics training every year, and there's a reason for that. And if we're going to have interactions with the community, we're going to have our officers to have better interaction with the community. Are there certain things such as this that we need to consider officers being exposed to on a yearly basis? When you get training like this on a yearly basis, it becomes a part of your mindset of what you're doing in your interaction. So I thank you, Madam Chair.
We have a question from Representative Eldridge.
Thank you, Madam Chair, and to the sponsor, I think you kind of went over kind of what I was wondering. What is it that we are not doing that would need to be done or reviewed on a yearly basis, or I guess what I'd refer to as a refresher course? And to Chairman Powers' comment, you know, I think a lot of that's just being humanity, you know, being kind toward one another and professional toward one another. And I don't pretend to know a great deal of what took place out in Memphis with the 5 officers, but I hear that there might have been a little bit more there because they didn't follow any protocol that I understand. I mean, when the video clearly shows that they just drug the young man out of the car.
Yes, sir. Yes, sir.
I mean, I mean, they might have had training the day before. I don't think it was about their training. I think there's something a lot deeper there. Okay. But that's just my personal opinion.
Yes, sir.
But I just wondered is what that we're not doing that would need to be reviewed every year with an officer. I mean, and I mean, I know and have worked with a lot of the police and sheriff's officers up in my area, and I mean, they seem to spot their problems, the problem officers real quick. They're working with them every day, and they know when they've got a hold of a bad one. I really think they do, and I don't think that it, you know, I just don't know that there's anything else that you could do. I don't think you can take a class on being humane, you know, in any respect. But anyway, I do appreciate you, and you and I have talked, and and you know I think you're a great guy. I know your heart's in the right place too. So, thank you, Madam Chair.
Representative Alexander.
My question really goes back to something our attorney, Matt, said. I want to make sure that I understand, and we may have to go out of session to ask him this, but I thought that he said that Post is not teaching what they're supposed to be teaching or not doing what they're supposed to be doing. And I know you referred to that, but I thought our lawyer also referred to that. Can we go out of session? Sorry.
We'll, without objection, we'll go out of session.
Thank you, Representative Alexander. Yes, that's correct.
Okay.
I'm not saying that they don't get to the same place in terms of the type of training that they're required to go through. But the Post Commission does have clear statutory duties to develop and implement plans of training. And as I understand it from their own testimony in committee, they review training that's developed by the local law enforcement agencies that's then sent to Post, and they look at it. Now, if you look at if you search certain terms like develop and plan and stuff like that, the only context that it comes up in statute is for the post commission to develop and plan training programs. There are 2 hits for develop that apply to local law enforcement agencies, that they have some very specific parts of training that they develop. Nothing for the training academy. They provide training at the training academy, but they don't actually develop, I don't think, the curriculum and the plan itself. So I think that they're getting training. They're getting the training that the post commission wants them to get. I just don't think that the post commission is actually doing the development and implementation of the training itself.
Is that what the post was put in place to do? Are they not doing their job? That's what I'm getting at.
Matt Money for the record. I don't want to say that they're not doing their job. I don't know I wasn't here in 1981, so I don't know how much the law has changed in that context. I don't know that I can answer that question. I can just tell you what the law says, and based on what I've heard, my observations, what I would conclude. And I say all that only to say that there's been some question as to whether Representative Hakeem's bill and the way it's structured is structured in a way
the right way
that's consistent with what post duties already are. So because post is already required to implement and develop plans, and that's what his bill does, it requires post to implement and develop this type of training program. So we felt like that was, when we put it together, we felt like that was consistent with what was already in code.
Good.
If that makes sense. And
Yes,
that's
sir.
why I'm giving the response that I'm giving. It's not to be critical of post.
Exactly.
It's just to say
No,
that
I knew you weren't.
his language is consistent with what's already in statute.
Okay. Thank you, sir.
Another question for legal, Representative Eldridge.
I thank you, Madam Chair, and I think this may be for legal.
You're
Pardon? And I don't know if we may need to call the folks back up here from Post and everything, but there seems to be a question about whether or not that the law requires them, to develop programs or curriculum. I know there's a difference between a program and a curriculum. So is there any clarity there?
Matt Money for the record. So again, I'll read the statute. It's in 38.8.104. The commission shall develop, plan, and implement law enforcement training programs. They receive and administer and expend local, state, federal, and other monetary assistance in the form of grants and otherwise. Establish uniform standards for employment, pre-employment, and requirements for certification. They consult and cooperate with local governments, political subdivisions, approve facilities for school operations, make or encourage studies on any aspect of police education, training, and recruitment, administer income supplements for police officers, and the list goes on. In terms of curriculum, if you'll give me just 1 second. Okay, so the Post Commission, as part of their powers and duties, shall establish minimum standards and curriculum requirements for the courses of study offered by or for any municipality, the state of Tennessee, or any political subdivision of the state, including universities, colleges, colleges of applied technology, and other educational institutions.
So I want to make sure I'm understanding this. They develop the program, but just what you read, you're saying that the Post Commission is responsible for putting together the curriculum that would be a part of that program?
Yes, to a certain degree, the statute TCA requires them to establish the curriculum. There's another section a couple down in 112 that says the curriculum requirements of the Tennessee Peace Officer Standards and Training Commission established by this part. So again, those are curriculum requirements that POST is supposed to be developing. Chokehold training requirements. It just says that it must be taught in the training facilities. But anyway, so that's just.
Representative Eldridge.
Can we get the gentleman back, the folks back up here? I think,
Sure.
I'm still a little confused about who's
still
doing
out of
what.
session, yeah.
And I
That's fine.
apologize, but I just don't understand. I'm just having a little trouble as to who's developing the curriculum for the program that's being taught. And so.
We have Jennifer Peck and Chip Kane. Please identify yourself and tell us what department you're with.
Jennifer Peck, Deputy Commissioner at Commerce and Insurance.
Chip Kane, Executive Secretary, Peace Officer Standards and Training Commission, Director, Tennessee Law Enforcement Training Academy.
Representative Eldridge.
Yes, thank you, Madam Chair, and thank you all too. And I don't mean to drag this out by no means, but I just want to make sure that that we understand. And what we're hearing, or what I'm hearing, is that you all are developing a program, and then where is that curriculum coming from for that program? Where is all of that information? Just like you mentioned about the chokehold, where is all that coming from?
You're recognized.
Thank you. So this is one of the reasons why we wanted to work with Representative Hakeem, because there are some really distinct nuances with the Post Commission and with Toledo. So the statute 38.8.104A, that requires the Post Commission to develop, plan, and implement training programs. That's the statute specifically references training programs, which Post does do and satisfy their statutory obligation by setting training requirements in rules. And that is the way in which Post satisfies their statutory obligation. And then Post also approves certain trainings submitted by local law enforcement agencies. So that is the way in which Post satisfies that statutory obligation. Representative Hakeem's legislation specifically says develop continuing education training curriculum. And so Post does the programs, but not the curriculum. The curriculum is designed by the local law enforcement agencies, and that is purposeful so that it is specific to the communities which they serve, and it's not a one-size-fits-all across. So Toledo designs the curriculum for basic police school. That's the Law Enforcement Training Academy. But Post does not design curriculum. They design the programs, and then they approve them by the local law enforcement agency. So it's really a nuanced position.
Thank you. So the curriculum is developed more by the local folks. Is that what I'm hearing? And they bring it to you as they tell you that we need additional training and say, for instance, the chokeholds, that type of thing. Is that what I'm hearing?
You're recognized.
Yes. So again, this gets very detailed into the difference between in-service, which is another issue, is that it doesn't distinguish between what's going to be basic police school training and in-service training. And if you would like to go more into that, Director Kane, I'm sure, can go into a little bit more of that.
Okay.
Do you want to go in? Please identify yourself and tell us who you're with.
Chip Kane, Tennessee Law Enforcement Training Academy, Tennessee Post Commission. So with regard to the training that we receive from local law enforcement agencies for in-service training, the statute also says we serve as a clearinghouse for training. So the training does come to us. We do review that training, and we either approve, as our Chief of Staff said earlier, we either approve that training or we reject that training for various reasons. As far as the the creation of the content of the training, the Tennessee Law Enforcement Training Academy, which also by statute does also staff the day-to-day operations of the Post Commission, we develop that within the academy. We develop the specifics. The Post Commission, by rule, sets out, that 488-hour basic training, everything that has to be covered, and the amount of time that has to be spent on those topics. For in-service training, which the local agencies, they're the ones that do their own in-service training. They may use a online provider, such as Police One or V Academy, to complete post-approved courses there, which are then transmitted to us when they're completed. But we approve all of those courses in those online catalogs. But the post rules do set out how much time has to be spent on each topic that we require. So, and there are certain mandatory requirements. As was stated earlier, we have certain requirements that are on the books this year: duty to intervene, de-escalation, officer wellness, public assembly interaction, and the community involvement, which those are in the rules this year. We also have firearms, child abuse and child sexual abuse, and mental illness, as well as emergency vehicle operations that are required on an annual basis. And most local agencies will send us their training curriculum for us to approve.
Is that all your questions?
Yes, thank you.
Anybody else have any questions? Representative Alexander?
Thank you, Chair Lady. I'm sorry. You mentioned that, I believe when you were up here before, that you had reached out to the sponsor to try to do some amendments on this, but he has not chosen to do that, correct?
You're recognized.
Yes, we did. Commissioner Lawrence, Director Kane, and I met for a little over an hour with Representative Hakeem, and we are not aware of an amendment that addresses those concerns.
Any more questions for our guest?
I have one more.
Okay, go ahead.
How often is in-service done?
In-service is 40 hours, and it's done every year, and that is...
Every year, every officer automatically has to do 40 hours of in-service training?
Yes.
Okay.
Any more questions for our guest? Thank you so much.
That's enough.
We're going to go back into session. Oh, we have another...
No.
No. We're going to go back into session.
Right now.
And I believe Leader Johnson has a question.
Madam Chair, I call the question.
Call for question. Question has been called. All in favor of this bill, please say aye. Those opposed, no. No. I'm sorry. Your bill failed.
Thank you, Madam Chair and members.
The balance of our bills will be rolled until next week. So do I have a motion to adjourn? Thank you. We're adjourned.